It's case number 241393FY, People State of Michigan versus Darius McCrary. Appearance for the record.
Good afternoon, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Good afternoon, Your Honor. Lindsay Abramson for Darius McCrary.
Mr. McCrary, good afternoon. State your name for the record. All right, so I think the AG's office filed a motion.
Yes, Your Honor. This is my motion regarding bond on the absconding file before you. I believe that the magistrate set the bond inappropriately and incorrectly in this matter. She set it at only $100 cash. When looking at the facts of this case in totality, I believe it should be much higher, and I'm asking you to do that today. As you may recall, the defendant was released on a cash bond last year, and Your Honor released him with a tether, with permission to leave the state so that he could work, but also then with the requirement that he return to court. He ended up not returning to court in June of last year, and a bench warrant was authorized for his arrest. It's my understanding that the tether is no longer on him either. So at some point, the tether was removed. He was apprehended attempting to leave the country, and that's how he was finally tracked down and then extradited back to Michigan to face these charges. So I think $100 cash is extremely unreasonable looking at those circumstances and the fact that he is a flight risk since he was attempting to leave the country. So I'm asking that you set it at a reasonable amount for the circumstances, which is not $100 cash, Judge.
Thank you, Your Honor. First of all, I want to put on the record that I don't believe this is an emergency at all. The prosecutor is well aware that bond, we just had court with Judge O'Brien on Monday, as I put in my response. The defendant cannot possibly be considered a flight risk when he has a total bond of $131,000. Judge O'Brien did change the order from no bond to $112,000, which we believe is actually a mistake and too high, because he only actually, not only, but the total amount of what he owes is $80,000 something. So we think anything beyond that is excessive and not constitutional, cruel and unusual punishment, violates fundamental fairness and due process. The $100 bond really that doesn't really mean anything. The prosecutor is leaving out the bigger picture, which is he's being held on a bond that, quite frankly, I have murder clients who have lower bonds than this. This is a nonviolent person. We are not minimizing the seriousness of what happened, but he needs to have a fair bond. And it's very interesting that the prosecutor did not note, there's two cases here before you. One is set, well, they were both set for next week. The prosecutor in her motion, in the state's motion, said that she doesn't think the magistrate that set these bonds had all the information, but she's only arguing that on this $100 case. She's not arguing that in the case where he got the close to $19,000 bond. So any assumption that the magistrate did not have the information is just an assumption. I think she probably did have all the information, and that's why she said a high bond in the other case, and probably realized anything else would be too high and not constitutional. He cannot post $112,000 or $131,000. These are cash bonds. He is not going anywhere. And as the court is well aware, the law requires that all defendants are entitled to a reasonable bail as a matter of constitutional and statutory rights. Pretrial liberty must be the norm, and this is not being released is the exception. And the court, under the law, U.S. Constitution and Article 1, Section 16 of the Michigan Constitution, these are the four factors the court is supposed to consider: the seriousness of the offense charge, protection of the public, previous criminal record, and the dangerousness of the accused, and the one that the court is probably concerned about, the probability or improbability of Mr. McCrary appearing at trial. He is most certainly not a danger to the community. I don't think well, I can't assume what the court thinks, but that has never been demonstrated. The party seeking the modification of the bond has the burden of proving this. And while this court can rule however it wants today, it was the clear intention of Judge O'Brien on Monday for him to have a bond. It was a very high bond, but for him to have it. So I don't think anything over this $131,000 would be constitutional. So this is a nonviolent offense. As far as I know, he doesn't have a criminal record. A lot of the people's argument here is their beliefs on stuff, but that there's no proof. Regardless of the charge that he absconded or obstructed, that is not proven. He is presumed innocent. He has the right to a trial, the right to a preliminary exam, and the prosecutor is essentially asking the court to punish him without him being convicted. Because if the prosecutor really wants what the state wants, which is the money to be paid, him sitting in custody is not going to do it. He has let me know that he has a podcast lined up that he can do from Michigan. He has an address where he can live in Michigan. I think he is well aware now what happens if he doesn't come to court. And we are not at all admitting that he intentionally violated anything. The state argues that he was trying to leave the country. We're arguing that he was working for a nonprofit organization building homes. That's something that will be addressed at the preliminary exam and trial. That's not a reason, we don't believe that's a reason for the court to raise a bond over $130,000. I get that this case is only $100, but I'm asking the court to take the bigger picture into account, which the prosecution has not. The way this is now, he's essentially he has a bond, but he can't post it. So we are arguing anything further, anything higher violates due process and fundamental fairness. If the court is inclined to increase the bond, we are asking it be no more than $5,000 at 10%, given what the other bonds are. Thank you, Your Honor.
All right, back on the record, 241-393 FY, People of State of Michigan versus Darius McCrary. Appearance for the record.
Sarah Brenner, Assistant Attorney General for the people, Your Honor.
Good afternoon again, Your Honor. Lindsay Abramson for Darius McCrary.
All right, Mr. McCrary, good afternoon. Again, state your name for the record.
Darius McCrary.
All right, so you may respond, Ms. Brenner, to Ms. Dickerson.
Yes, Your Honor. She brings up the bonds that were set in the child support matters. They're not relevant to the bonds set here in the absconding matter. The child support bonds were set pursuant to the statute and what that requires for those bonds. When looking at this alleged crime, his absconding from bond, I think that needs to be set appropriately as well. It cost the state nearly $8,000 to extradite him again this time when he was apprehended trying to leave the country. So I'm asking that you increase the bond. I'm asking for $250,000 cash surety. It's not relevant what's set in the child support matters. He posted his bond really quickly last year when you said it. You gave him the opportunity to get out and work. He did not take you up on that opportunity, Your Honor. He did not make any payments. Instead, he did not return to court and he removed the tether. So I'm asking you to set the bond appropriately in this alleged absconding case.
All right, so Circuit District Court Case 190551 FY was a case in which the exam was waived and bound over to Circuit Court. That was bound over on December 7th of 2023. That case went before Judge Daniel O'Brien of the Sixth Circuit Court here in Oakland County. He was arraigned on the bench warrant on October 31st. I do remember obviously setting the bond at 25% of what was owed on that case. I don't remember how much it was. How much that was. I know his new case that's before me is $18,868.32. But it is quite concerning, you know, when I give a person an opportunity to get out on bond. First, you're supposed to make payments. According to Ms. Brenner, no payments were made. Allows you to go out of state on tether to work. and to make payments towards your arrearage, which is a rarity, and the AG's office agreed to that. And then catch you going away or attempting to flee to Mexico without the tether on. So cutting a tether is also another federal charge, but that's neither here nor there. So I am quite concerned, Ms. Abramson. I mean, he's not a danger to the community. I never said he was, but you know, it's a lot going on. It's money being expended. He owes child support money. The state of Michigan is expending money. Taxpayers, hardworking taxpayers, are spending money to get Mr. McCrary to come back to Michigan and handle his duties of child support. So before I make my ruling, miss, because this is very expensive. Now I'm thinking about the taxpayers of the state of Michigan. Does he have any other allegations of arrearages in child support? Because he might be a resident of Michigan, because he's going to be here for a while. If you intend to press those charges, can we get those in so we can handle all of this at one time and get it up to circuit court if it goes there?
Yes, Judge. He doesn't have any other children here in the state of Michigan.
I'm saying not any other children, but any other date ranges in which he failed to pay child support.
No, Your Honor, there aren't any others.
So this is all it?
Yes. His
Okay.
child emancipated in July while he was still on absconder status.
Okay. All right. So
May I add one thing?
hold on one second. So the absconding from the bond was a result out of the 19 case. So you can go ahead and proceed.
Your Honor, my client wanted the court to know that he also has health issues. He's had 2 strokes in the last year, and he is feeling those symptoms today. He was supposed to go to medical right now, but he missed the appointment to come to court. So he does have some health challenges as well.
Okay, so we'll make sure his file is marked medical or indicate to the Oakland County Jail that they need to keep close attention to him because of his medical. But I'm inclined to raise the bonds. Because once again, it was a slap in the face to allow him to go to work and, you know, pay money on his arrearages, and he just basically told Judge Bowie, like, the hell with you, dude. Like, I'm gonna do what I want to do. And I don't like that, you know. He's gonna get treated the same way I treat anybody else who disrespects me, and I give him an opportunity to. The ball was in his court and he missed, so his bond will be raised. So I guess my question is, what's the arrearages in the I'm gonna be fair and just assess the arrearages in full. What's the arrearages in the 19 case?
It's just under 82,000, Judge. Do you want an exact figure?
Yes. So if it gets paid, it can go straight to FOC.
Yes. And let me bring that up, Judge. I think that was the intention of Judge O'Brien, and that's why he had set it at what he did. But his current balance is $81,658.35. And we would also be seeking the extradition costs as well as part of his sentence. So that's an additional $15,000.
Okay. So your bond in the absconding case, sir, will be $96,658.35 cash only to be posted in your name. So we will raise the bond to that.
Edward Arthur Winslow. Son, I am ashamed of you.
Your Honor, I just wanted to state that we do not believe that's, we respect the court's ruling, but I just want to state for the record, for appellate purposes, we don't believe that is a constitutional bond. It essentially makes him non-bondable. He now has duplicative bonds for what he owes in multiple cases, and we think it should just be one bond. That's what's fair. He doesn't owe $200,000. He owes $81,000 plus any cost of extradition if that is ruled that way.
So he owes, so let me tell you something, he just owes money. Here's the deal. If we're gonna have kids, we're gonna have the responsibility to take care of divided by 125. So he owes $75,473.28 in 241,392 FY. He owes, in this case, child support of $81,000.
No.
They're the same case, Judge. They're the same case. Yeah, they're the same case.
They're not
The one you're looking at locked in time when the arrears were at that point. That's why they were slightly less at that point in
Okay.
time.
All right, so,
It's all covered by Judge O'Brien's bond, the entirety of it.
the bond in my case that just got here to, circuit to my court, this $18,868.32. This hasn't even gone.
And our argument, and we're filing a motion to reconsider.
But take that up with his court, like he can't, because
But
this case could,
The 18,
this case could just get dismissed down here at district court. He shouldn't be setting a bond based off a district court case.
he did.
That's not his jurisdiction.
So the 18,
So I'm not gonna change it. He's gonna have to change that at circuit court. I'm not gonna change it on my end. Because
may
our
we,
bond was appropriately set by the magistrate.
may
Our bond was appropriately set.
I'm sorry, Your Honor. May we get a written order so we can appeal this as an interlocutory appeal?
That he set, that the 112,000, I have nothing to do with that. So you're gonna have to file a motion before him on that, but on the case in which the magistrate properly set the 18,000, I don't know why that got encompassed with anything, because the case is still here at district court.
But the court just said, and correct me if I'm wrong, Your Honor, this court just set an amount of 96,000 when he's already has to pay 112,000 and then another 18 or 19,000. This is like hundreds of thousands of dollars over what the arrearage is.
The 112,663, what is that number? Does that include the extradition, Ms. Brenner?
I think that he
112?
included, I think he didn't tell us the numbers he was including, Judge, but he took the arrearages. He asked me what the extradition costs were, and he also asked me what his original bond was set at, which was just under 24,000. So I think he factored that in as well.
Okay, if the arrearages are covered, then I won't put a money on it, but I will deny it. So he doesn't have to pay a bond. I'm gonna deny, well, in that case, I'll deny the bond because I don't want him to pay more than what he owes. But at the same time, he cut it, allegedly, a tether is gone that was with him, and he was trying to leave to Mexico. I'm not happy about that, Mr. Epperson. I appreciate your zealous advocacy, but that's very disrespectful. And they
I'm
cost
sorry, what
tax,
you're-
hold on 1 second, and it cost taxpayers $15,000 to go get him? No, thank you. So his bond will be denied on the Absconding case. He doesn't have, and then whatever cash, he can work that out with circuit court, that number. I'm not
Thank
gonna
you.
penalize him.
Your Honor, we are asking for a written order. Do you want me to submit that to the court?
And then if I don't like it, I'll write mine.
Oh, okay, so I'm sorry, it's hard to hear. You do want one?
Submit one, and if I don't like it, I'll write my own.
Thank you, Your Honor. Appreciate it.
Thank you.
And I'm sorry, I
All right.
wasn't raising my hand at you. It was to my client.
Works. You're all set. Thank you.
Okay, thank you.
Your Honor.